Hello! Today we're talking about the Individuals with Disabilities Education Act. Remember that any materials provided by Washington Civil and Disability Advocate, also known as WACDA, are for informational purposes and not legal advice. WACDA is not responsible for the consequences of your reliance or any information provided. Your use of informational materials does not create an attorney-client relationship or any other relationship or the expectation of confidentiality between you and WACDA. Views expressed in informational materials are those of the individual author and may not reflect the views of WACDA or its individual staff members. If you need legal advice, you must seek advice from an attorney regarding specific legal issues. In 1975, the Education for All Handicapped Children Act was passed and established the framework for special education as a government responsibility. Many of the principles found in IDEA today were started with the Education for All Act. And then in 1990, the Act was revised and renamed the Individuals with Disabilities Act, also known as IDEA. Since then, various presidential administrations have revised the Act, notably to include younger children, but the basic principles have stayed the same. The purpose of the Act, as demonstrated in the congressional findings shown on the slide, is to give children with disabilities full access and opportunity to educational opportunities and community life. The goal is to give children with disabilities the chance to become as independent as possible and learn as much as possible while they're still in school. In addition, under Title II of the ADA, the government is required to provide as integrated community opportunities as possible for people with disabilities, which includes in the school system. You can see our video about the Olmstead decision for more information.
IDEA covers children in 13 specific categories. These categories are autism, deafblindness, deafness, emotional disturbance, hearing impairment, intellectual disability, multiple disabilities, orthopedic impairment, other health impairment, specific learning disability, speech or language impairment, traumatic brain injury, and visual impairment, including blindness. Children who are not in one of these four categories will not qualify for services under IDEA, but several of these categories, like the category for multiple disabilities or other health impairment, are designed to be broad to include as many children as possible who require special education services. IDEA is centered around requirements for a free and appropriate public education. Let's break this down by the different sections of that requirement. A free education means that schools cannot charge parents for special education services. Special education services are paid for by federal and state grants, and parents do not pay for them personally. Appropriate education is the most complex of these topics, and we will be coming back to it later to describe it in greater detail throughout our presentation. But as a broad overview, schools must provide an IEP, individual education plan, reasonably calculated to enable a child to make appropriate progress. This, generally speaking, means that schools have to have a plan and services to provide special education so that every student can make appropriate progress in their education. Finally, public. Students must be educated in the least restrictive environment by the state. If a school does not make a free and appropriate public education available to a student in a timely manner, a student who has previously received IDEA services can be enrolled by their parent in a private school and reimbursed for the cost of that private school. But the vision of IDEA as a law is to bring as many students as possible into the public school system. One of the central concepts of IDEA is the creation of modifications and accommodations. A major recent 2017 Supreme Court case described how much educational benefit is required for modifications and accommodations to be appropriate under IDEA. This case was Andrew F. versus the Douglas County School District, and involved a young student with autism who was not receiving appropriate educational services in his public school and was transferred to a private school and seeking reimbursement for that cost. The Supreme Court in that case said that the plan for a student has to be reasonably calculated to make appropriate progress, and Andrew raised the de minimis standard previously set by the Rowley case. Andrew says that schools need to be providing services that don't just allow the student to make the barest contribution to their education, but that when a child is able to be in the general education classroom, they have to be receiving accommodations to allow them to advance from grade to grade and pass their classes. And when a child cannot advance with the general classroom, the education plan must be appropriately ambitious, whatever that looks like for the child. This means that schools do not have to do every single thing possible to provide modifications and accommodations for a student, but the modifications and accommodations have to be sufficient for a student to be at least getting an education, rather than receiving ineffective services that do not provide any educational benefit at all. IDEA also requires school districts to locate, identify, and evaluate students with a disability. IDEA does not allow schools to shrug their shoulders and let students with a disability go without services because the school didn't know and didn't care to know that these students needed help. Schools have the responsibility to child find for all students ages 0 to 21. This includes students in a private school or in a public school. It includes students successfully passing from grade to grade. Basically, any student that the school district has reason to suspect has a disability covered by IDEA has to be located and evaluated. The evaluation also has to be an appropriate one. The case mentioned on this slide is a case in Seattle where an assessment team was brought together to evaluate what services would be needed for a teenager with a diagnosed mental health condition. But the assessment team in that case did not contain anyone who had knowledge about the specific condition that this student had. And the court ruled that the assessment team has to include at least one person who has the knowledge and expertise about the condition that your student has, so that the assessment team can make a fair and accurate assessment about what services might be needed.
So we had been talking about free and appropriate public education and possible modifications and accommodations for students. So these are all kind of taken together into an individualized education plan, also known as an IEP. And that's an education plan that's unique to the student and their needs. It's a unique plan that lays out the program of special education instruction, supports, and services the student needs to progress and succeed in school. It's designed to provide free and appropriate public education for the individual student. Some of the content that would be in the IEP would be the student's academic performance up until the time when they're writing the IEP, academic goals, the list of services and accommodations that the student would need to reach those goals and to have the free, appropriate public education. Also, the amount of time in the general classroom versus the amount of time in the special education classroom. The goal is to have the student in the general education classroom as much as possible. So the IEP also considers how much of that is possible. Some of the other considerations that go into the IEP are the strengths of the child, the concerns of the parents for enhancing the education of their child, the results of the initial evaluation or most recent evaluation of the child. So the idea is to have ongoing evaluations of the progress. The academic, developmental, and functional needs of the child, the communication needs, and the behavioral needs. So that all goes into thinking about where the student will be throughout the day and also what kind of modifications they would need. In terms of the IEP team, the ones who determine what the individualized education plan looks like, so that includes general education teachers, special education teachers, specialists, care providers, or therapists that might interact with the students throughout the days, possibly the student. And you also want to have the parents there. The parents have a right to a meaningful participation and say in the IEP plan, so they're very important. However, they don't have the ultimate say or veto on specific provisions. The school still has discretion in some areas. We'll talk a little bit more about that when we talk about seclusion and restraint. Also, the IEP team meets and reviews at least once annually, but they'll also meet and review if one member of the team thinks that there should be an amendment or a revision to the IEP. On this slide, you can see some sample IEPs of what it might look like for a specific student. You can see under IEP goals and objectives, they're very specific goals for the student to reach. And you can also see underneath a list of modifications and accommodations for the student, such as reading test questions aloud or using larger print. These are all with the goal of helping the student reach those objectives. And again, reminding that these IEPs are supposed to be appropriately ambitious. Then on the right, you can see the IEP lists the student's present level of abilities and then what the student needs to progress and what kind of accommodations will help them progress.
One of the other most important concepts of IDEA is that of the least restrictive environment. A student must be placed in the least restrictive environment that is appropriate. The least restrictive environment is usually a general education classroom with all of the students who are not receiving these services, but that environment is not appropriate for every student who is receiving special education services, and so the IEP team must make decisions about what is appropriate with the consideration that IDEA wants students to be in the least restrictive environment possible and as integrated with other students as possible. I've listed a couple of cases here that give us important considerations about least restrictive environment. The case Hunt v. Bartman out of Missouri stated that the least restrictive environment must be expressly considered in the IEP meetings and by the IEP itself. It's not enough for a school district after the fact to say that they considered something if it wasn't laid out in the plan. The case Hudson versus Bloomfield Hills, a case out of Michigan, ruled that when a student must be placed outside of the neighborhood school or the school that they would normally go to if they weren't receiving services, which can happen if another school in the district is the only one that can provide certain more intensive services. Distance from home is a factor that should be considered when deciding what the least restrictive environment is. Placing students in schools that are long distance from their homes can become a difficulty in transportation and in having parent interaction with their education environment, and is not considered the least restrictive environment. CL versus Scarsdale Union Free District, another Michigan case, was looking at a student who had been placed in a private school. If the public school is not fulfilling its free and appropriate public education requirements, the private school chosen by the parent does not have to be in the least restrictive environment. Placement considerations about integration and about location are not placed on parents choosing private schools. One of the most critical and most controversial issues under IDEA is school discipline. An example of how this interacts with IDEA came up in the Jamie S. versus Milwaukee Public School District case, where the school district had a policy that required students with more than 10 days of suspension in a year to be evaluated for disabilities so that their child find requirements were being met. School districts don't have to use this exact policy, but they do have to have some sort of policy in place so that students who are being disciplined frequently should be evaluated for disabilities, especially emotional and behavioral disabilities that might be causing these discipline issues. Students with disabilities who are already identified and evaluated often have specific due process rights related to discipline, especially if a procedure is laid out in their IEP. For some students, it's very important that when you're planning services and supports for this student, that their rights with regard to discipline are laid out very clearly so that a student who is acting out for a reason related to their disability is not unduly punished for their disability.
Restraint and seclusion are a controversial part of school discipline, especially in relation to special education. It's important to talk about because when not implemented correctly, it can cause a lot of harm, and it's also something that the U.S. Department of Education is currently working to address. So what is restraint and seclusion? The U.S. Department of Education defines it as restraint of a student means restricting the student's ability to move his or her torso, arms, legs, or head freely, and seclusion of a student is confining a student alone in a room or area that he or she is not permitted to leave. For us in Washington, we have the national standards found in IDEA, and then we have other specific standards found in our Washington laws, known as the Revised Code of Washington, or the RCWs. For the IDEA standards, It's important that schools know they cannot treat special education students differently than general education students in regard to restraint and seclusion and discipline. Like we previously mentioned, in the IEP, there are specific instructions and safeguards. There should be very specific instructions in the IEP about how and under what circumstances restraint and seclusion may be used. For instance, in the case referenced below, Miller versus Monroe School District, a Washington case, the child was allowed to be isolated in the front office for no more than 20 minutes, and that was in the IEP. Parental input is important, but they cannot have a veto. For instance, in the Miller case, the parent wanted their child to have no restraints, but because of this child's behavioral difficulties, the school district could reserve discretion and have the possibility of limited restraints if needed. Also under IDEA, restraint and seclusion cannot be used to deny a student free and appropriate public education. For instance, if the student is constantly being taken out of the classroom, being isolated, they may no longer be receiving that free and appropriate education if they're being kept from progressing academically. At that point, they may also not be placed in the least restrictive environment if they're being restrained and secluded in that way. For Washington laws, restraint and seclusion is only allowed when reasonably needed to control behavior imposing an imminent likelihood of serious harm. This is more restrictive than IDEA. Again, there is ambiguity in what imminent or serious harm might mean. The school staff applying seclusion or restraint must only do what is absolutely necessary and stop as soon as possible. There's detailed follow-up procedure in Washington that involves informing the principal, the parents, writing up a written report, and then there's an annual report published to keep school districts accountable. So if one school district is using these methods more than another, then they're held accountable for that. So these headlines are a few extreme and tragic examples of what can happen when restraint and seclusion is applied incorrectly or without appropriate discretion, also when it's not individualized to the particular student, which is why it's really important to have a discussion about that in the IEP meetings. IDEA puts into effect an administrative process for parents to bring claims and concerns about their child with disabilities experience in public schools. This is referred to as procedural safeguards and due process in the IDEA statute. A lot of the procedure looks similar to bringing a civil lawsuit in court, and there is some variation among the states, but the basic process looks similar. First, what kind of concerns or claims can a parent bring? They can bring claims concerning the identification, maybe something with the child find mandate, the evaluation, or educational placement of the child, or anything regarding the provision of the free and appropriate public education. Basically, the issue should relate back to whether the child is getting that free and appropriate public education. If the child has not been correctly identified, evaluated, or placed in the right classroom with the right accommodations, then the free and appropriate education could be threatened. The kind of issues I just mentioned are substantive, so concerning the actual education program. Procedural flaws are not always amounting to a denial of a free and appropriate education, but procedural failures that interfere with the free and appropriate public education can fall under due process. An example would be not giving a parent a prompt due process hearing or a prompt IEP meeting to discuss an issue. Then the student might be left in flux for an extended period of time without the free and appropriate public education. Once a parent has a claim, they need to bring the complaint within 2 years of the alleged incident or violation. The school district has an opportunity to respond, just like in a regular lawsuit, and mediation is required before moving on to a due process hearing. If no resolution is reached within 30 days, an impartial hearing officer is appointed to preside over what proceeds similar to a civil trial, but through the school system. Both parties have a right to legal representation, they make disclosures, and have evidence and the ability to question witnesses. But again, it takes place through the school system, not the court system. After the due process hearing, the hearing officer makes a decision in favor of either the school district or the parents and the student. Both parties may appeal the decision to an educational review agency, although that may vary state to state. If that decision is still unsatisfactory, a parent may file a complaint in state or district court within 90 days of the hearing decision. This lawsuit proceeds like a regular civil suit, and either side may recover attorney's fees. If you find yourself in a situation where you might want to pursue a formal complaint and go through this process, you must contact an attorney that specializes in this area for counsel that relates to your specific situation. Something important to keep in mind is that parents must first exhaust all administrative remedies under this due process procedure through IDEA before they can bring claims under the ADA Title II, the Rehabilitation Act, or any other federal laws. This is required when the same relief could be sought under IDEA. However, if you're seeking a different kind of remedy, one that couldn't be sought under IDEA, one that does not involve free and appropriate public education concerns, you may be able to go straight to the court system. But again, please contact an attorney about your specific situation.
IDEA is a federal law, but each state Department of Education is in charge of putting into place regulations and procedural standards to implement IDEA in their state. One example of a type of regulation that a state would make would be related to the curriculum requirements for special education classrooms to determine what students would be learning in which grades. All state substantive and procedural standards that exceed federal law, that are greater than what IDEA requires, are incorporated into IDEA. When you bring an IDEA case, all of your state standards are going to apply. The Burlington case is an example of a case that lays this out very clearly. You don't have to bring a suit under a specific state law for these standards. Your IDEA case will be just fine.
Please feel free to check out these additional resources for more information about IDEA. Thank you for listening today.